Hello, everyone. We are Group 5. It is myself, Nick, Curtis, and Matt, and we have been tasked with dissecting and presenting to you the Heart of Atlanta Motel Incorporated versus United States case. An obvious groundbreaking case, one of the most important cases in the battle for civil rights. And really, I think at its heart argues what powers and scope Congress is afforded in regulating private businesses, how private business owners conduct their business. Before we get into the case, we need to talk about the lead up to the Civil Rights Act of 1964. Now, the case we will be discussing came shortly after the passing of the Civil Rights Act of 1964. So we need to go all the way back to President Lincoln and his battle for ratifying the 13th Amendment. Now, if you remember, Lincoln despised the practice of slavery. He also argued that the emancipation of the slaves would so undermine the morale of the Confederacy, if you remember the Civil War was going on at the time, that it would completely weaken their military and bring about a swift end to that horrific conflict. Now, if we skip ahead a little bit, the 13th Amendment is ratified. Lincoln approved a joint resolution of Congress, submitting it to the state legislatures for ratification in 1865, and Section 1 of the 13th Amendment outlawed slavery and involuntary servitude. Section 2 gave the U.S. Congress the power to enforce this article by appropriate legislation. Now, this was not the end to the horrific treatment of our black citizens. Opposition states, many of them in the southern United States, used measures such as poll taxes, literacy tests, and constant threats of violence and harassment to keep the African American citizens disenfranchised, but nothing more blatant than Jim Crow laws. Now, Jim Crow laws were a collection of state and local statutes that legalized racial segregation, segregated waiting rooms, segregated water fountains, amusement parks, pools, just think of a public meeting place, and it was segregated. Now, you remember in the groundbreaking case of Brown versus Board of Education in 1954, the Supreme Court ruled that educational segregation was unconstitutional. And as the ball moves forward, we find in 1957 the establishment of a civil rights section of the Justice Department and a Commission on Civil Rights, which is tasked with investigating discriminatory acts and conditions around the nation. Now, just before the Civil Rights Act is enacted, John F. Kennedy is president and is facing rising protests around the nation, none more visible than the Birmingham, Alabama protests in which protesters were attacked by police dogs and high-pressure fire hoses by the then Birmingham City Commissioner Eugene Connor. Nearly 1,000 of the demonstrators were arrested, and this violence was broadcast live on television to not only the nation, but the world as well. So I wouldn't say this is the sole catalyst, but this was certainly more pressure for Kennedy to get this legislation passed. For Kennedy, this was a personal issue. He saw this as a moral issue, but also as a legislative issue. In a famous speech, you can hear him say,
"And this nation, for all its hopes and all its boasts, will not be fully free until all its citizens are free. And this nation, for all its hopes and all its boasts, will not be fully free until all its citizens are free."
Sadly, President Kennedy would not live to see the Civil Rights Act enacted. If you remember, he was assassinated in Dallas. But the Civil Rights Act was enacted in 1964. No longer could people be denied service simply based on the color of their skin. And it also barred race, religious, national origin, and gender discrimination by employers and labor unions. And additionally, it forbade the use of federal funds for any discriminatory program. So it was signed into law by Lyndon B. Johnson. You can see a picture of him there with civil rights leader Martin Luther King, who said of the Civil Rights Act that it was nothing less than a second emancipation. Now, we finally get to the case. So I'm not joking when I say the Civil Rights Act was passed, and hours, yes, hours after the passing of the Civil Rights Act, the proprietor of the Heart of Atlanta Motel, Morton Rolston, a real piece of work, filed a suit in the U.S. District Court. Now, I want you to pay attention to this map here because this will become important as we start discussing the case. Notice that the Heart of Atlanta Motel is, yes, located in the heart of Atlanta, in between two major thoroughfares. Now, this motel, Mr. Rolston's motel, practiced the policy of refusing to rent rooms to African Americans. After the passing of the Civil Rights Act, Mr. Rolston brought a case to district court seeking a judgment that Congress had in fact exceeded its constitutional authority by enacting the Civil Rights Act, and that the motel, his motel, was deprived of its due process rights to select their customers. This case went to district court, and a three-judge panel upheld the Civil Rights Act as constitutional under the Commerce Clause. We will talk more in depth about the Commerce Clause as we go on, but on its base level, it allocates certain powers to Congress to regulate Congress among states and with foreign nations and Indian tribes. Now, as is in Mr. Rolston's nature, he appealed this decision to the Supreme Court, raising the question in this case, is it within Congress's power to prohibit racial discrimination in places of public accommodation by using the Commerce Clause? Now, I'll let you look up the full Commerce Clause, which can be found in Article 1, Section 8, Clause 3 of the U.S. Constitution. But again, are the powers given to Congress under this Commerce Clause enough to force a private business and Mr. Rolston to abide by the Title II of the recently enacted Civil Rights Act? Now, Mr. Rolston, the petitioner, brought his arguments and said that, in fact, Congress had exceeded its Commerce Clause to the powers given to regulate interstate commerce. He believed that his Fifth Amendment rights were violated because he was not free to operate his business the way he wanted to. He claimed that the Fifth Amendment guarantee of due process and just compensation for taking private property, this applied because he could not choose his customers, and this is a gem of one. He claimed that it violated his 13th Amendment, the prohibition of involuntary servitude, because it compelled him to rent rooms to African Americans. Now, the arguments from the other side by the United States of America, it was argued that Congress was well within its rights to use the Commerce Clause because the activity in question, Mr. Rolston not renting rooms to African Americans, that greatly affected interstate commerce. The court would go on to find that Congress had provided, enough evidence to demonstrate that the discrimination by Mr. Rolston and his motel, just having a lack of rooms available to African American patrons who were traveling between states, this greatly affected interstate commerce. So the Commerce Clause, in fact, applied here and held strong. So the court also ruled that some of Mr. Rolston's arguments, they were not necessarily depriving him of property or liberty because he was still being financially compensated for the rooms that he chose to rent to the patrons, his primarily white patrons, that he was still renting rooms to. Now, the majority opinion by Justice Clark at this time even more solidifies the idea that the court held that Congress was well within its rights to exercise the Commerce Clause. Justice Clark goes on to say in his majority opinion, the action of the Congress and adoption of the Civil Rights Act as applied here to a motel, which conceitedly serves interstate travelers, is within the power granted by the Commerce Clause of the Constitution as interpreted by this court for 140 years. And I think that's important because the word interpreted has meaning. It has a lot of meaning. The court is there to interpret the foundation of the Constitution and apply it as our culture develops and progresses. So this is, I think, a classic case of that in the majority opinion of Justice Clark. So we come to the final decision. In a 9-0 vote, unanimous decision, the court argues that Congress acted well within its jurisdiction of the Commerce Clause in passing the Civil Rights Act. And remember, after much of my blabbering, you remember that this entire case is about whether Congress exceeded its powers in passing the Civil Rights Act and if that impeded upon Mr. Rolston's ability to regulate his own business. Now, obviously, the interstate commerce at the heart of the Commerce Clause is at the root of this case. As 75% of Heart of Atlanta's motel clientele came from out of state. Like I mentioned previously, it was located between two major interstates and highways, which was a big sticking point in this case, a clear representation that Mr. Rolston's actions directly impeded interstate commerce. And it also, the court held that Congress had not forced Rolston into the involuntary servitude, as he put it, and that it was in fact so insubstantial that the court didn't need to discuss it anymore. He was not deprived of property or liberty because he was still being financially compensated for his rooms. Although we had a 9-0 majority opinion in this case, Justices Black, Goldberg, and Douglas had concurrent opinions. Specifically, Justice William Douglas had criticized the court for not basing its decision on the 14th Amendment as well as the Commerce Clause. Now, Douglas argued that protections against racial discrimination under the 14th Amendment, which if you remember is the Equal Protection Clause, were much stronger than under the Commerce Clause, and that an approach such as that would really avoid a case-by-case analysis, as this case did, of whether, separate instances of racial discrimination affected interstate commerce. He believed that in his opinion, the humiliation of those being affected by being turned away for rooms because of the color of their skin, that humiliation, goes against the right granted by the 14th Amendment. So this would have been much more solid than strictly relying on the Commerce Clause to solve this case. As we come to a close on this case, I think the significance of the decision is pretty clear. I think the decision upheld and solidified the enforcement of the Civil Rights Act desegregation in this country. I think it began a cultural shift in the United States towards complete desegregation. I think we're still working towards that now in our current climate. I think it also set a precedent for Congress to regulate private businesses if it affected interstate commerce. The courts found through the Commerce Clause that they could settle this matter, that they did have rights to regulate how Mr. Rolston conducted his business. And I think it also showed the general populace how the courts really interpret the Constitution, written hundreds of years prior. So in closing, we want to talk briefly about subsequent cases that have dealt with this idea and the Commerce Clause in general. One that stood out to us was the U.S. versus Morrison in 2000. Briefly summarizing, a freshman student was allegedly assaulted and raped repeatedly by fellow students. And during a school conduct hearing on that complaint, one of the students in question admitted having sexual contact with her, despite the fact that she had repeatedly said no. The college failed to punish those students. They punished one of the students with a suspension, but that was later struck down. And a state grand jury did not find sufficient evidence to charge either of the men with a crime. To give a little background, the United States Congress had passed the Violence Against Women's Act in 1994, and that contained a provision for a federal remedy to victims of gender-based violence such as this, even if no criminal charges were filed against the perpetrators of that violence. So this went to the Supreme Court. They held that parts of that Violence Against Women's Act of 1994 were unconstitutional because they exceeded the powers granted to Congress under the Commerce Clause. Yes, the Commerce Clause and the 14th Amendment Equal Protection Clause. So that court, in a 5-4 opinion by Chief Justice William Rehnquist, delivered the majority opinion. That court had held that Congress lacked the authority to enact the statute under the Commerce Clause or the 14th Amendment, since this since that statute did not regulate an activity, in this case being sexually assaulted, that affected interstate commerce, nor did it redress harm caused by the state. Justice Rehnquist also held that the Commerce Clause only gave Congress the power to regulate activities that were directly economic in nature. He held that the Equal Protection Clause did authorize the law, because that clause only applies to acts by states, and here not to acts by private individuals. So this is, I think, a complete 180 in the court's attempt, the United States attempt to use the Commerce Clause for prosecution. And I think in closing, it goes to show the delicacy of the law, and I think also the open door to interpretation of the Constitution written hundreds of years ago. Thank you.